Mazi Nnamdi Kanu is out. He's fully out. Finally, don't sue the Nigerian Medical Association and 10 doctors for 550 million over falsehood. You remember when Justice Omotosho ordered the Nigeria Medical Association to examine Mazi Nnamdi Kanu? That was September. You understand? Just listen to this news, my people. This institution has made the court to deny Mazi Nnamdi Kanu bail, and now Mazi Nnamdi Kanu has decided to sue them for them to now come and explain to the people of the world why they did not examine him, and they went ahead and submitted an old report. You understand? Just listen to this news and kindly share this video, my people. It is becoming hotter. It's becoming hotter. And remember that Mazi Nnamdi Kanu has equally filed to appeal court. Not be small thing, no, but let's get on to this one. Mazi Nnamdi Kanu sues Nigeria Medical Association 10 doctors for 550 million over alleged falsehood. The detained leader of indigenous people of Biafra, IPOB, Mazi Nnamdi Kanu, has filed a 550 million lawsuit against the Nigerian Medical Association, NBA, and 10 medical practitioners, accusing them of issuing a falsehood medical report against him. The development was disclosed on Friday by one of Kanu's lawyer, Barrister Maxwell Opara, in a video posted on his page. Now, listen to Barrister Maxwell Opara.
Mazi Nnamdi Kanu, this is the High Court of Abuja. So, Mazi Nnamdi Kanu has filed a 550 million naira suit against the Nigerian Medical Council and the 10 medical doctors that conspired and issued a fake medical report against him. And the court ordered that they should examine Mazi Nnamdi Kanu, but that they never did. So they went to wrote what they call medical report, and it was that medical report that made the court to refuse Mazi Nnamdi Kanu's bail. So based on that, we have written to them, and they did not show any remorse. So we have filed a suit against them. It's 550 million naira suit against the Nigerian Medical Council and other medical doctors. So that is the position. Thanks and God bless you.
Now, listen. The legal team said they had previously written to the NMA and the doctors seeking clarification and accountability, but received no response or indication of remorse, promoting the initiation of this lawsuit. Are you getting it? Now, remember, Kanu has been in the custody of the Department of State Services, DSS, since June 2021, following his kidnap. You know, he was extraordinary rendition from Kenya. He was kidnapped from Kenya down to Nigeria. He has been in the Nigeria DSS dungeon since that June 2021 till this 2025. My people, is getting hotter. Imagine a sincere citizen of a country, and you don't love Mazi Nnamdi Kanu. Now I'm asking you, what is that crime you will tell me that Mazi Nnamdi Kanu has committed? Tell me one evidence, crime. In a scene, you have seen Mazi Nnamdi Kanu committing that crime. Are you guys not getting it? But there are a lot of them that have killed people, yet they were freed. Still, that same law that freed them in Nigeria, why can't that same law apply justice on Mazi Nnamdi Kanu? These are people that were caught, that killed people, life. They were charged and were later released, discharged and acquitted under the law, operational law in Nigeria. Then why can't such law, justice, be applied to a man who you have not seen in a crime, who you have not seen shooting anybody, but you are alleged terrorism? 2021 till this present time, no particular crime. Even when a court has discharged and acquitted him, then Supreme Court or whatever, whoever, now appealed, they are still on that case till today. But there are a lot of them who have killed. The practical example of Deborah. The practical example of Deborah in our school because of blasphemy. In a WhatsApp group, the school WhatsApp group, she wrote in that WhatsApp group, they should start posting about religion in their group, that this is a study group. These people ganged up, caught Deborah, and killed her. Yes, they were charged and later acquitted. Say no evidence. So the death of Deborah, how she was killed, stoned to death, and they set the remains ablaze. So it's not enough evidence. Are you guys getting? And so many other atrocities they are doing in some part of Nigeria that the media is not even reporting. Even the one they managed to report, no justice is passed. But look at the case of Mazi Nnamdi Kanu, because he's a Biafra, because he's a Christian. That is why. And some gullibles, some naive people of Nigeria, some of you are applauding Nigerian government for the injustice being melted on Mazi Nnamdi Kanu. And you want Nigeria to be better. We are saying one Nigeria, unity, progress in Nigeria. When there is a man who is being kept somewhere unjustly, and you expect the country to move forward. Something, that person, the person's spirit, when you go realizing that this person will you offend, and because of say you offend this person, now you make you the face of so many difficulties. Sometimes you may not see the person to even apologize. A lot of people that Nigeria has injured, a lot of people that Nigeria has happened to, and they didn't get any justice. And you want Nigeria to work. And those foreign powers that are backing Nigeria up, they are just using these people they punch there as your leader. They are just using them.
Okay, now let's quickly dive into the second update. Please pay very, very close attention. Right, still from Mazi Nnamdi Kanu. Yeah, Nnamdi Kanu has prayed the Court of Appeal in Abuja to stop Justice James Omotosho of the Abuja Division of the Federal High Court from continuing with his trial. Mr. Kanu, the leader of Indigenous People of Biafra, IPOB, is currently being charged on 7 counts bordering on alleged terrorism. Justice Omotosho had on November 7 fixed November 20th for judgment in the trial after Mr. Kanu's defense was foreclosed following his insistence that he would not enter his defense under a repealed law. However, in a motion on notice dated November 10 but filed on November 12, Mr. Kanu, who personally signed this document, sought one relief. He prayed the appellate court for an order staying the proceeding of the trial court in case number FHC/Abuja/CR/383/2015. Federal Republic of Nigeria versus Nnamdi Kanu, currently pending before Justice K. Omotosho. Mr. Kanu sought the order pending the hearing and determination of the appeal. The IPOB leader urged the appeal court to look into the lower court's decision on no case submission. The alleged refusal of the lower court to determine its jurisdiction and the validity of the counts under which he's been tried. He also urged the appellate court to look into Federal High Court's foreclosure of the appellant's right to defend the case by fielding witnesses. Mr. Kanu, in his 9-ground argument, averred that despite the jurisdictional question raised before the trial court, it refused to rule on them. He said the trial court refused to evaluate the evidence of the prosecution witnesses. The cross-examination questions to determine whether the evidence was discredited under cross-examination. Mr. Kanu said that though he filed a list of witnesses to be called in defense of the case and indicated that his defense would come up, and the appellant court fields witnesses immediately, the court determined its jurisdiction. The court refused and held that the decision would only be given on the objections during judgment. According to him, the trial court, while refusing to rule on the objection, foreclosed the appellant's right to defend against the heinous allegation leveled against him. The trial court has adjourned the matter for judgment on the 20th of November 2025. Now pay attention. If the application is not granted, which is this application that Mazi Nnamdi Kanu has filed to appeal court, if the application is not granted, the appellant may be unlawfully convicted without being afforded the opportunity of knowing the validity of the counts, the jurisdiction of the trial court, and offering defense on the merits. Further proceedings on the matter will certify the appellant's right of appeal and any appellate decision fait accompli, he said. Mr. Kanu said neither the court nor he would be prejudiced if the application is granted, the case having been prolonged since the year 2015, only to commence before the instant court sometime in this year, 2025. He said it will be in the interest of justice to grant the application and allow the matter to be taken on the merits. Mr. Kanu, who disengaged his lawyer, had opted to represent himself in the charge before Justice Omotosho. He had questioned the court jurisdiction to try him based on the charge, which he claimed was invalid on the ground that it was based on repealed laws. The IPOB leader submitted that the Terrorism Prevention Amendment Act 2013 and the Customs and Excise Management Act (CAP) C45 LFN 2004, on which the charge was hinged on, had been repealed. He further argued that the court's failure to take judicial notice and the laws had been repealed rendered the proceedings so far conducted in the case a nullity. Mr. Kanu claimed that his trial was a conspiracy and had been predetermined, accusing the British authorities of wanting him to be convicted and jailed. He alleged that he learned of the British authorities' intention about his fate about 1.5 years ago. However, Justice Omotosho said he was unaware of Mr. Kanu's claim. The judge, who said that he had no relationship with the British authority, also clarified that he was not the judge during the period Mazi Nnamdi Kanu referred to. The IPOB leader insisted that he would only enter the witness box to give his testimony after he had been told under which law he was being tried. Justice Omotosho, in his ruling, held that Mr. Kanu, having exhausted the 6 days allocated to him by court to conduct his defense, had waived his right to do so. The judge said he would have extended the days allocated to Mr. Kanu to conduct his defense if he had opted to open it. He said Mr. Kanu, having failed to utilize the opportunity given to him to conduct his defense, could not claim to have been denied the constitutional guaranteed right to fair hearing. The court has given opportunity to the defendant under Section 36 as required by the Constitution, and I will not allow this to continue. It is based on this, without hesitation, that I say that the defendant has waived his right, Justice Omotosho said, and adjourned the matter until November 20th for judgment. But now, Mr. Kanu has written to appeal court to stop Justice Omotosho from continuing that proceedings. My people, let's stay tuned and wait till that 20th and see what is going to happen. Please kindly share this video and leave your opinion down the comment section. Bye for now.